Hi, my name is Attorney Michael Goldstein. I'm a bankruptcy attorney in Massachusetts as well as a consumer debt advocate. I'm here today to talk to you about this thing called a meeting of creditors or a 341 meeting and exactly what that is. Essentially, after you file a bankruptcy petition, you have to attend a hearing in court where you have to testify about your assets and liabilities. Now, a lot of times when my clients hear that they're going to have to go to court, they get a little anxious or a little nervous. The thing that always puts them at ease is the knowledge that they're actually not going to go into a courtroom. There isn't a judge, there isn't a jury. It's really as simple as just a meeting room where there'll be another attorney called a trustee who's been appointed by the court to administer the bankruptcy estate. And they're going to want to ask a few questions about the schedules and statements. It's their opportunity essentially to make sure that everything on the schedules and statements are true. Now, this is also the opportunity for creditors to show up and ask you questions about the debts that you incurred to them specifically. Now, in my experience, that very, very rarely happens. Typically, only two situations occur when a creditor shows up to these meetings. One is if you haven't filed your taxes, and the IRS or the state taxing agency will show up just to find out why and when you're going to do that. The second is if there's a creditor who believes that you, in fact, incurred a debt by means of fraud. For example, you told someone that you make $1 million a year in order to get a credit line of $200,000 when in fact you made 15 bucks an hour. Now, what happens in the actual meeting is pretty straightforward. The meeting itself, your hearing, will only take about 1 to 5 minutes. And again, it's in a small meeting room, sometimes in a courthouse, sometimes might even be in the basement of a bank. It really depends, or at a registry of deeds. And what happens is that the trustee will present you with a piece of paper, which will have your signature, and she or he will want to know, in fact, is that your signature? Was everything true and accurate at the time that you signed the papers? Did you read and review everything before you signed it? Has anything changed? After that, they'll just ask you a few follow-up questions, such as, do you have the right to sue anybody? Does anybody owe you money? How did you get into financial difficulty? Where do you live and where do you work? Other than that, each trustee might have his or her own additional questions based on what they see in your petition, but for the most part, that's what they're looking for. Now, again, this is the opportunity for the trustee just to ensure that everything that you said is true and accurate. Once you complete this meeting of creditors, hopefully this is the one and only time you're going to have to appear in any bankruptcy proceeding. Now, the only other time you might have to appear is if, in fact, there are some motions filed in your case. Now, if you have any additional questions about these meetings of creditors, or in fact questions about bankruptcy and consumer debt related matters, please feel free to give me a call at 781-595-3800 or check us out online at consumerdebtradio.com. Again, my name is Attorney Michael Goldstein, and I'm happy to have brought you this video on bankruptcy related matters.